Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Well, good morning, everyone. It's such a privilege to be here today with Judge Murphy on Zoom. And we have Holly Teeter from Kansas with us. Before we get started, we have a very special ceremony, and I'm going to call on Chris Wolport, the clerk of court, to perform it.
Thank you, Your Honor. I'm here this morning with a preliminary motion to swear in 4 new members to the bar of our court. Before making the motion, with your permission, I'll introduce the candidates. Would our candidates for admission please approach the lectern? Our candidates for admission this morning are 3 of Judge Ide's law clerks: Grant DeLone, a graduate of the University of Chicago Law School and a member of the Illinois Bar; Anastasia Shabalov, a graduate of the University of Chicago Law School and a member of the DC Bar; Hannah Wander, a graduate of Columbia Law School and a member of the DC Bar; and we also have one of Judge Teeter's law clerks, Justin Brown, a graduate of Vanderbilt University Law School and a member of the New York Bar. Before making the motion, are there any questions or comments from the bench?
Apparently not.
I respectfully move for the admission of these candidates to the bar of the United States Court of Appeals for the 10th Circuit. May I administer the oath?
Please do.
Please raise your right hand and repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will conduct myself as an attorney
that I will conduct myself as an attorney
and counselor of this court
and counselor of this court
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and I will support the Constitution of the United States.
Congratulations. Thank you.
Congratulations. Thank you so much. All right, we're going to go ahead and get started and call the first case, Brinkerhoff Restaurants versus Castle Pines Golf Club, number 251032. Please approach.
Good morning, Your Honors, and may it please the court. My name is Mark Levy, and I represent the Castle Pines Golf Club. Castle Pines is the owner of the renowned Hummingbird mark that it has used for golf club services, including bar and restaurant services, for over 40 years. This is a trademark case regarding Brinkerhoff's use of the word equivalent of the Hummingbird mark as the dominant part of its mark for a bar and restaurant business located less than 4 miles away from Castle Pines. Castle Pines moved for a preliminary injunction. The district court denied that injunction, and Castle Pines appealed. Castle Pines asks this court to reverse and remand to the district court. Today, yes, Your Honor.
Counsel, which of the marks is Castle Pines challenging on appeal? Are you challenging both the composite mark and the word mark, or just one or the other?
We're challenging both, and both the composite mark and the word mark, which is, I think, was clarified in the briefing.
Okay, and was that raised in your opening brief, the composite
Yes,
mark?
it was.
Okay.
And in addition to that, just so that it doesn't get lost, there is a third mark that is at issue, and this is footnoted in our opening brief or the reply brief, which is the original mark, which is just a bar Hummingbird logo mark, which Brinkerhoff applied to register. It applied to register 3 marks: the original bar Hummingbird logo, the new bar hummingbird at the Brinkerhoff logo, and the word mark. All three of those were applied for, which required a declaration of a bona fide intent to use in commerce of those marks, and all remain pending before the Trademark Office. Now today I'd like to address three key legal errors that the district court made. The first error concerned the most important factor of the similarity of the marks. The district court's conclusion that the marks at issue share only nominal, if any, similarity contradicts the district court's finding that the marks have identical dominant components and shows that the district court misapplied the law that required it to give greater weight to identical dominant components.
So, counsel, I hear you emphasizing misapplied the law, but isn't this a factual question, and don't we defer to the district court's decision?
There is the similarity of the marks, the determination of the similarity of marks is a factual question, but to get to that fact requires application of legal principles. And the problem here that's very clear in the district court's decision is that its ultimate conclusion that the marks share only nominal similarity, if any, contradicts its earlier finding that the marks have identical dominant components.
And you say that's a legal problem?
Yes, it's a legal problem because—
Why isn't that a factual? Maybe the district court got the facts right one time and got the facts wrong in another time, but I don't understand how that turns it into a legal conclusion.
Well, I think there are two ways of looking at it, Your Honor. One way of looking at it is if you look at it as a factual finding of similarity of the marks, and its ultimate conclusion was shared nominal similarity, if any, then we would say that that is a clearly erroneous factual finding on the assumption that it applied the law correctly. And by the law here, what I'm referring to are the two legal rules that this court has announced and applied, that similarities of the marks get more weight, and in addition, the dominant parts of each mark also get more weight. So if you assume that the district court applied the law correctly, then the district court's conclusion that the marks share nominal similarity, if any, when the marks, according to the district court itself, shared identical dominant elements, shows that the factual finding is clearly erroneous. We've looked at it through a different lens, which is that although the district court acknowledged the legal rules, there's no way you can find that the marks share nominal similarity, if any, unless the district court did not apply the law, which is why we looked at it as a legal error.
Counsel, let me ask you this. I think Judge Ide has this right about it being a factual question, but regardless whether it's a factual question or a legal question, as you say, don't you have a problem on this dominance issue with our precedent in King of the Mountain Sports versus Chrysler Court?
Well, Your Honor, I don't think we have a problem there at all. And the reason is that in the district court's decision, in the appendix, page A1238, the district court found as a matter of fact, to which this court should give deference, that the Brinkerhoff mark, that the word hummingbird is a predominant element of the hummingbird mark. The district court's already made that finding. So the problem—
But wasn't the thrust of the district court's analysis is that you look at the depictions as a whole? Wasn't that the thrust of the district court's ruling?
Well, you do look at them as a whole. That is also a principle of law that's appropriate. We're not saying that any element of the mark should have been ignored. The problem here is the district court found, where I quoted from the decision, that the word hummingbird was the predominant element of the Brinkerhoff mark, and then somehow came to the ultimate conclusion that the marks share share only nominal similarity, if any, which is directly contradictory. Because remember too.
Well, couldn't that be because it didn't feel that hummingbird was the predominant feature of your client's mark?
Well, no, actually, Your Honor, no, because the district court also accepted our argument that the Castle Pines mark, which is an image of two hummingbirds, is equivalent to the word hummingbird. The court accepted that in the decision, and that's the correct decision.
But that doesn't mean that just because it was a part of it doesn't mean it was the dominant part.
Oh, Your Honor, the Castle Pines mark, that is all of it. The Castle Pines mark is an image of two hummingbirds. That's all it is.
Well, thank you. I get that.
Yeah. So what you have here, just to cut to the chase, you've got the Castle Pines mark, which is equivalent to the word hummingbird. It's not, hummingbird isn't just the dominant part of the mark, it is the mark. And you compare that to the Brinkerhoff mark, which the district court found that the predominant element of that, in this case, the logo mark, was hummingbird. And there's no way to make that consistent with its ultimate conclusion that the marks share only nominal similarity, if any, and the similarity of the marks factor favors Brinkerhoff. Makes no sense at all. So whether you look at it as
you know what? Help me with this. Why doesn't that make perfect sense under King of the Mountain?
Because you have to look at the whole mark?
It makes perfect sense with King of the Mountain. Is that you can have the same words, but the marks are not that similar.
I think because if memory serves, that the words in King of the Mountain were not determined to be the predominant elements of both marks. That's the problem here. Of course you look at the whole...
You do have that wrong. It's because when the court was talking about that, it says, assuming the phrase King of the Mountain constitutes the dominant portion of the defendant's logo, as plaintiff argues. So that's exactly what they were saying. It was the words.
Well, Your Honor, I would say in this case, the differing factor in this case is that the district court came to the conclusion that the marks share only nominal similarity, and that is either a clearly erroneous conclusion if it applied the law correctly, or you have to say that the district court didn't apply the law correctly. Either way, if given that, at a minimum, that requires reversal and remand to the district court to reconsider the similarity of the marks factor in light of that very clear error.
I have a question. You've mentioned geographic proximity in your argument today, and you also mentioned it several times throughout the briefing. What role does the geographic proximity play in this case, or where does it fit in to the analysis?
Thank you, Your Honor. It fits in connection with the similarity of the goods or services issue. There is some, I don't have it right off the top of my head, but in our briefing, there is some authority for the fact that you look at geographic proximity in considering the similarity of the goods and services used in the case.
Well, just to follow up on that, then how about the fact that there's golf and then there's a bar? I mean, right? Isn't there a difference there?
Well, I would say no, Your Honor, respectfully. For two reasons. One is that the golf services for which Castle Pines Mark is registered encompasses bar and restaurant services for purposes of the registration.
But isn't it predominantly golf?
It is a golf club, but it also, if you look at the underlying record, there is undisputed evidence, incredible evidence of the predominant use of the Hummingbird Mark in connection specifically with the bar and restaurant services offered by the club, which have been offered for over 40 years. So in other words, you don't have to just keep your laser focus on the registration. We have common law rights in the use of the mark in the bar and restaurant services at the club. Those services are, and this is another place where the district court erred, the district court found that the services were dissimilar. That's a clearly erroneous finding. It's undisputed that Castle Pines has provided bar and restaurant services under its mark, just like the Brinkerhoff intends to provide bar and restaurant services at its restaurant under its mark. The fact that those services at Castle Pines are offered at a private membership club doesn't make the services any more different. Now, I'll give you a silly example. If you go to, Costco is a membership club. You may go to Costco to fill up your car at the gas station. Those services, gas station services, are the same as the gas station services provided by the Shell down the road that's open to the public. The fact that Costco is a membership club doesn't make the services any less similar. Now, the fact that it's a private membership club, I'm not saying is material, it's relevant, it should be considered, but the services are the same, and the district court clearly erred in finding that they were not.
Yeah, counsel, what do we do with the proposition the Patent and Trademark Office has these in two different categories? It has a category of country club services and it has a different category of bar and restaurant services.
Those categories,
as they were dealing with that issue with the application by the Brinkerhoffs,
those categories are purely for
nothing ever came up as to similarity.
First of all, the classification system for the Trademark Office has absolutely no substantive bearing. That is for administrative purposes only, and it has absolutely no bearing on the similarity of the goods or services. That is a complete red herring, Your Honor.
And you have authority to that effect?
Yeah, it's in our briefing on that. I don't have it.
Your authority that the Patent and Trademark Office categories are wholly irrelevant. There's authority in your brief for that.
Yeah, there is. They're administrative, and
that's fine. If it's there, we'll find it.
Yeah.
An additional issue you raise in your briefs is the district court's analysis of actual confusion, and I just want to make sure I didn't miss it. There was expert testimony offered at the district court level, but I didn't see any reference to it. Did the district court judge make any findings about the experts in the order?
The district court there was a survey offered by Brinkerhoff, presented by an expert. We had an expert rebut that survey evidence. The district court completely avoided it with a 10-foot pole, didn't touch it. The reason why we think he didn't touch it is because our expert very persuasively explained that their survey wasn't worth the paper it was printed on because of defects in its administration and how it was made.
All right, thank you.
Counsel, your time has expired.
I see that.
You can conclude in one sentence.
In one sentence. Well, Your Honors, I was unable to get to the other two errors, which is fine. It's in our briefing. But we believe that once the errors are corrected, what you're left with is a very strong case of likelihood of confusion that the district court just simply missed. And we ask for reversal and remand for the district court to reconsider this in light of your opinion.
Thank you.
Thank you.
Please proceed.
Good morning, Your Honors. May it please the court. My name is Jessie Appellant, and I am here representing Brinkerhoff Restaurants, LLC, for the appellee. With me is Tim Sullivan, also of Studio IP. The policy behind trademark law is to protect the consumer from confusion. Trademark law is distinct from other forms of intellectual property as it is concerned with the consumer and the possibility that the consumer might be mistaken as to the source or sponsorship of its goods or services that it has paid for in the marketplace. The analysis to determine if a likelihood of confusion exists is a complex, multi-part factual analysis trying to get to whether a consumer would or would not be confused. The district court did a careful analysis of all the factors and came to the conclusion that there was no evidence of a likelihood of confusion in this case. Castle Pines is proud of their brand, but that does not give them the right to tell businesses in the area what they can or cannot do with their branding without a legal basis to do so.
Counsel, can I get you to start with your opponent's argument that there's an inconsistency, which he claimed was a legal error, in the findings?
Sure. We believe that under the law, a preliminary injunction decision is reviewed under abuse of discretion standard, and all that was found under the court under the likelihood of confusion analysis were findings of fact which are to be reviewed under the clearly erroneous standard.
Okay, then why aren't there two factual findings that are inconsistent?
I believe there are not factual findings that are inconsistent.
I'm just asking you to respond to his primary argument.
Yeah, okay, understood. Under the Pegasus case, Your Honor, I think that is where they're leaning into the argument that when you see something, right, it brings up that same connotation, right? And the court actually did acknowledge that the hummingbird is itself, right, the largest portion of this mark. So they considered that case, they considered that analysis. However, given that the actual whole of the likelihood of confusion analysis is to actually look at a comparison of the composite mark as a whole and consider all of the factors at once, the court did that and yet still found that there was not a likelihood of confusion given all of the factors put together.
But saying the main part of the mark is the same, how can you have an overall determination that there is no similarity?
Sure. And the court went through a detailed analysis looking at the fact that one hummingbird is of watercolor and it is forward-facing with wings outspread. There's only one, not two. It's not a geographic image. It's not two from a side profile. There's no circles surrounding the hummingbird that's presented. There are words presented which are with our client's mark, which is bar hummingbird at the Brinkerhoff. Also noting that at the Brinkerhoff, while it is a house mark, it does have significant strength. There was evidence in the record that our client has 700,000 customers come through its doors every year, whereas Castle Pines has 400 members. And even with the, golf tournament that came through, the BMW tournament, there's evidence in the record to support that there were 100,000 people that came to that versus our clients' 700,000 that come through their doors. There is some weight given to the house mark here with Brinkerhoff, such as the Kellogg case.
Well, so I guess your argument is all the factors that you just listed outweigh the fact that the primary similarity is the hummingbird.
Absolutely.
Okay.
So my question kind of ties into that. Which mark do you understand to be being challenged on appeal? Do you understand both the composite and the word mark, or one or the other?
Your Honor, I believe that they have focused on the word mark because they have really leaned into the fact that the words themselves equate what the image of Castle Pines composite mark is, logo.
And did the district court separately analyze the word mark versus the composite mark? Like you just went through the description of how the composite mark differed from Castle Pines mark, but did he also analyze the difference between Castle Pines mark and the word mark?
Yes, Your Honor, the district court did look at the word mark as its part of the logo and the words themselves. So the court analyzed both.
But a word mark doesn't have any font or stylization to it, is that correct?
Correct.
Okay, thank you.
You're welcome.
I also have an additional question. So the district court went through the various factors that are outlined for likelihood of confusion. Is the failure to consider any one of the multiple factors in the likelihood of confusion analysis automatically constitute reversible error?
No, Your Honor.
And what's your authority for that?
The authority is that in the context
And if it's in your brief, I'm not trying to waste your
Oh,
time.
sure, sure. Yes, I mean, it's in our brief, but I was trying to find in actually the King of the Mountain case, where it does talk about that all of the factors are to be, the strength of the plaintiff's mark can outweigh any other factors. And it is true that there's not one determinative factor, that it is, and Sally Beauty is probably the best authority for that.
Thank you.
But can I ask you, those cases don't say that you can just not talk about a factor, right? Do you have authority for that?
That you cannot discuss a particular
Yeah,
factor.
Exactly.
The court did go through every factor that is actually to be determinative to find likelihood of confusion or not. So we can look at each of those factors that the court looked at, but they did consider the strength. They discussed that even if the mark for Castle Pines has strength, it is limited to the golf industry. The court, during our preliminary injunction hearing, also discussed the conceptual strength of the mark and discussed how it would lean towards finding the mark to be arbitrary. The court did look at the sight, sound, and commercial strength and impression of the mark as a whole. The court looked at overlap in services. The one consideration that the court...
Well, the counsel effectively, and it's not unusual, that the court didn't really consider actual confusion because there was no acceptable evidence that there was actual confusion. So even in this case, there's no consideration of that factor, correct?
Correct. I would say the court did consider the survey evidence that was put forth, which would give a reading of whether or not there is likelihood of confusion possibility, whether there is actual confusion as it stands now, because the marks were presented to the survey participants in an actual ever-ready test to see whether or not there was likelihood of confusion presented with the people that were surveyed.
And you're saying the court relied upon that survey?
The court took it into its overall analysis as it was part of the preliminary injunction hearing.
Did he make any findings, though, about... I'm asking because I don't recall seeing any mention of the expert testimony in reviewing the district court's opinion.
I will look briefly to see if I see anything that jumps out as well.
Well, you would agree with this, wouldn't you, counsel, is that since Brinkerhoff had not been in business using this mark, there could be no confusion there. And so the only confusion would be from showing the marks to different people and have them opine on whether they thought it was confusing or not. That would be the only way to do so, isn't that correct?
Correct.
All right. And the court didn't accept that.
Yeah, considering the courts above, this is what the court states regarding the lack of consumer confusion resulting from the marks.
Here's my point. It's not unusual for courts not to talk about the lack of actual confusion when there's insufficient evidence of that. Isn't that correct?
Yes, Your Honor. They do note that the other factors need only minimal discussion because of their finding of the lack of similarity between the marks and the lack of intent to tread on the goodwill of the golf club as well. The district court did not err in their decision, and I would like to note that, the Lanham Act does state that a likelihood of confusion is as to affiliation, source, or sponsorship. And the court did, in fact, look at the strength of the marks and did, in fact, discuss and cite to the Kellogg case, noting that even if there is a strength of the mark in this case for the sponsorship analysis, that it is only to golf. There was not sufficient evidence in the record to support that the Castle Pines Golf Club mark is otherwise as strong of a fanciful mark, such as in the Pegasus case.
Am I correct that there was, first of all, there was live testimony in the evidentiary hearing, correct?
Yes, Your Honor.
And there was also a presentation of videos of the environs of both,
Yes, Your Honor.
at least the entryway to the golf course and where the restaurant was going to be located. Is that correct?
Yes, Your Honor. Yes, the video actually depicted, what the drive is like going to the golf club. There are several stop points where you would have to either be a member or give a member's name in order to pass through the gates. It is a private course, and members of the public are not allowed to even drive up to the golf course unless you are invited by a member. The front of the bar at the Brinkerhoff is connected to the Brinkerhoff restaurant. As you walk up to an arch, there's both logos are presented at the front entrance, and it also shares a parking lot with the.
What do you mean when you say both logos?
Sure, the Brinkerhoff restaurant. The Brinkerhoff restaurant is connected to the bar Hummingbird at the Brinkerhoff.
Yes, I understand that.
And so as you walk up, you see both of those logos as a consumer as you walk up to that archway from a public parking place.
When you say both, what are you talking about? The Brinkerhoff restaurant or bar?
Yes, the Brinkerhoff restaurant and the bar Hummingbird at the Brinkerhoff logos are both presented to the consumer as they walk up to the restaurant. And it does share a parking lot. Oh, sorry, go ahead.
And there's also one of their other restaurants there.
Yes, Your Honor. Yeah, it shares a parking lot with Savina's Mexican Kitchen, which is also owned by the Brinkerhoff restaurant family. Those factors, I believe, were weighed heavily by the district court in determining the amalgamation of evidence that really supports that a consumer would not be confused as to the source of this particular bar and restaurant because of all of those factors that a consumer would be presented with as they are accessing the restaurant itself.
Getting back to the location of the Brinkerhoff facilities, is it in a strip mall?
It is across from a strip mall, yes, Your Honor.
Is it across from the strip mall? It's not part of the strip mall?
Correct, Your Honor.
Okay.
I did want to point out one thing that counsel discussed in terms of the fact that it is undisputed that the golf course is offering bar and restaurant services, and at no point has Castle Pines Golf Club registered for bar or restaurant services, and those services, again, are not available to the public. There was evidence in the record that someone who is a member of the public would have to be escorted with a member of the golf club and wear a particular colored jacket even to attend one of the restaurants there.
Counsel, your time has expired. Now, you can give us a summary in one sentence.
Sure. Yeah, in conclusion, the district court did not err in their decision. Castle Pines presented no evidence supporting potential confusion. The district court had sufficient basis in facts to make its findings, and because the district court did not abuse its discretion in finding that Castle Pines failed to make a strong showing of likelihood of success on the merits, we ask that this court affirm the district court's decision. Thank you.
Thank you.
Thank you.
Your Honor, excuse me, may I have 1 minute for a vote?
No, thank you, though. The case stands submitted, and we are going to go to the next case. Thank you for your helpful arguments. All right, we're going to move to our next case, 254062, Kosher Eats versus Welch.
Good morning, Your Honors. May it please the Court. Kenneth Chase for the appellants, plaintiffs below. If I could reserve 3 minutes for rebuttal, that would be fantastic.
You have to, as you can see, you have to keep track of your own time.
Thank you, Judge. The district court's order should be reversed because the standard set forth in Twombly and Iqbal was turned upside down. This case involves a theft of $8.3 million from small businesses. There was an advance fee fraud scheme that's at issue here. Pursuant to the advance fee fraud scheme, a law firm drafted a very unusual loan agreement. That unusual loan agreement provided that the borrowers would pay to Messner Reeves 25% of the amount of an enormous business loan. This enormous business loan, which was done to scale, and there were commitments made for over $40 million of these loans, these loans were to be at 6%, no personal guarantee, no real estate collateral, no payments for 10 years. Interest only at 6%, no real estate collateral, no personal guarantee, no payments for 10 years, basically free money. The only catch was pay Messner Reeves 25% of that loan, and then Messner Reeves will hold that money, that deposit money, for up to 90 days in its sole possession and control. And if for whatever reason the loan doesn't fund, the money will be given back to the customer, to the borrower, to these members of the public. That didn't happen. The BLOC agreement, which was drafted by Messner Reeves, was riddled with false statements. It induced these victims to pay into Messner Reeves' trust account over $10 million, $8.3 million of which was from the plaintiffs, the appellants. It was paid in, and then it disappeared. And then there were lies. What's at issue here, Your Honor, is the irregular nature of the law firm that perpetrated this advance fee fraud scheme. This law firm has 77 attorneys, experienced attorneys, who identified themselves in every context, publicly, in sworn statements to the court, in referring to each other.
Counsel, Counsel, help me with this. I'm just having a real difficulty distinguishing between Messner General Partnership and the law firm, Messner Reeves. Can you help me with that?
Absolutely, Your Honor. There is a corporate registration called Messner Reeves LLP that is a corporate form that we argue exists concurrently with a unregistered general partnership. That corporate form, Your Honor, has a partnership agreement. That partnership agreement actually wasn't considered by the district court, but even if it was, it contains exactly what was alleged in the First Amended complaint. There are 11 partners in Messner Reeves LLP, not a single human being. All of the 11 partners are corporate forms. 0 of the 77 attorneys who identified themselves.
That's not unusual, is it? for a law firm to be set up like that?
Maybe it's not, maybe it is, Your Honor, but it's not in the record how usual or unusual it is. The district court did cite a news article, a Reuters news article, talking about larger law firms, the AmLaw law firms, which Messner Reeves is not one of them.
Well, let me ask you this. There's no written partnership agreement for Messner General Partnership, is there?
That's absolutely right, Your Honor. There is not a written agreement, and there does not need to be under partnership law in Colorado. It's 764-202, Section 1. All a partnership requires is 2 or more people organized together, conducting a business, associated together for profit. That's it.
So I think to kind of tag on to the questions that have been asked. So you allege that there's a limited partnership, which is Messner Reeves, the law firm. You also allege these individuals all worked as lawyers for that limited partnership law firm. You also allege facts that you contend show the existence of a general partnership, the alleged Messner General Partnership. And those facts include that the individuals all called themselves partners, they shared office space and resources, contributed resources, etc. But these facts could possibly support or be consistent with the existence of a general partnership, but all those facts just as likely point to nothing more than the lawyers working together in a limited partnership law firm, something specifically alleged to exist in this case. So my question is, what facts have you alleged that would push the existence of the Messner General Partnership specifically, versus just the law firm, across the line from possible to plausible?
That's an excellent question, Your Honor. There's no prohibition of the 2 corporate forms or the 2 forms existing simultaneously. There's no prohibition in law. So it's certainly feasible that that occur. What's unusual about this case is that there was an assumption that these attorneys were, quote, income partners. It exists nowhere in the partnership agreement. There's no terminology of what it means to be a non-equity partner. These other law firms that are probably referenced in the Reuters article have terms of engagement or terms that set forth, here is your compensation structure, here's what it means to be non-equity, you are not a partner here, here are your voting responsibilities. The assertions that were made by the defense, none of which should actually be considered in a Rule 12 context, because the allegations are considered in the light most favorable to the plaintiff and accepted as true. The defense's assertion was, we have no paperwork, we have no agreement, we just decide to call each other partners all the time. Publicly, in social media posts, we announce lateral partners coming in to join the partnership, to come in as a partner. Never was it said that that only means job title. That's just nowhere in the record except defense's unsworn representation.
So are you saying that those representations that you just talked about, including like calling each other partner, that is somehow inconsistent with the existence and operation of Messner Reeves LLP?
No, Your Honor, we say it's consistent. We're taking the attorneys at their word. We are saying these lawyers said that they're partners because they're partners in a partnership. They're either partners in a partnership or they're saying they're partners, but they're not partners at all, in which case they would need some sort of a public disclaimer or caveat or limitation.
The Messner Reeves is a partnership. It's just a limited liability partnership.
Absolutely, Your Honor. Yes, it is.
All right, so can't they call themselves partners and referring to their position in Messner Reeves and their relationships rather than some thing called Messner General Partnership for which there's no documentation?
Of course they could, Your Honor, and it would not be hard for them to do so. They could certainly say, when they swear under oath, as 8 of them did in submissions to tribunals, they could say, my job title is partner. However, I am not actually a partner in a partnership. I swear my rate is XYZ. Every time it was, I am a partner at Messner Reeves. It didn't say that it was just a job title.
But wouldn't your theory of the Messner General Partnership coexisting with the Messner Reeves law firms essentially give anyone an avenue to skirt the existence of a written partnership agreement?
If the facts support it, Your Honor, then perhaps. Your Honor is asking a very good question, which is, what's the limiting principle?
Right.
The limiting principle is, number one, don't steal $8.3 million and have the existence of a partnership agreement be the linchpin of a Rico claim. That's number one. So this irregularity of the structure is in the context of very damning and very alarming allegations of the theft of a lot of money that's still unexplained and still hasn't been returned. But Your Honor's question is, what would stop plaintiffs from just alleging that a law firm with a proper corporate formalities, which this law firm did not have proper corporate formalities. If there are proper corporate formalities, the case wouldn't go anywhere. If these lawyers actually are not partners and actually didn't behave as partners and actually are income partners or whatever it is, and there's documentation as to it, there wouldn't be a viable legal claim.
So let me ask you, is a linchpin of your case that the representations that have been made by the individuals involved in Mesner Reeves, that's a linchpin of your case for liability, correct?
As to the Rico, Your Honor, it is, because that's the enterprise.
Okay, well, that's our focus is the Rico claim.
Absolutely, Your Honor. That is the enterprise.
All right. Well, you answered my question. It's a linchpin.
It is, Your Honor. Yes, it is the enterprise, which is an association of persons that are conducting the racketeering activities, which is at least 5 counts of wire fraud and at least 5 counts of transporting stolen.
No, wait a minute. My questions were about Mesner Reeves. You're now talking about Mesner General Partnership.
That's correct, Your Honor. Did Your Honor ask a specific question as to Rico, as to the Mesner Reeves LLP?
My question was, which I thought you answered, and that is it a linchpin to your Rico claim that the individuals involved in Mesner Reeves LLP, their representations are a linchpin, as to partnership and things like that? It's a linchpin to your Rico claim.
It is, their representations are important, Your Honor. The linchpin is not exactly the terminology of Rico.
Are they very important to your Rico claims?
Your Honor, I would say that they're in the constellation of facts, all of which are important under the totality of the circumstances, which is the proper standard. It was asserted in some of the briefing by the.
All right, could you explain to me what's the rest of the constellation besides these representations?
These attorneys not only represented themselves as partners in all contexts, represented each other when they're talking about each other in all contexts, made public statements about themselves and each other in all contexts. Those are the verbal statements. Put themselves out to the public in all contexts as partners. Then also engaged in the activities of the partnership. The actual partnership agreement says only one person has all the control. That's not even logical that a law firm would even function in that manner. So there's an actual.
Now you're talking about the Mesner Reeves.
The Mesner Reeves actual partnerships. One person has votes. It's not even a partnership the way it's actually set up in terms of Mesner Reeves LLP. But the way the law firm actually conducted itself was, there's 77 people are practicing law as partners. If I could yield and reserve my time for rebuttal.
You may.
Great. Thank you, Judge.
Good morning. Excuse me, I'm overcoming a cold, but good morning. My name is Troy Rackham from the law firm of Spencer Fain, and I'll be arguing on behalf of all of the appellees today. As the briefs make clear and as Your Honor's questions make clear, plaintiff's appeal on the Rico claim rises and falls based on the enterprise element. And the law is very clear, enterprise needs to be distinct from the enterprise defendants, but the appellants never pled cognizable Rico enterprise distinct from the defendants because the alleged Mesner General Partnership doesn't exist. And the law is clear that the fact that a lawyer represents himself in an email or an affidavit as a partner doesn't convert to some general partnership status under partnership law, both under Colorado Uniform Partnership Law and the federal cases cited in the briefs. The case law is very clear on that topic. But even if the plaintiff alleged sufficient facts which, if accepted as true, would establish a plausible Mesner general partnership theory. Plaintiff's RICO claim failed on the other elements. They didn't allege personal participation in operation by the defendants in the enterprise or a sufficient pattern of continuity, and they failed under Rule 9b. But let's talk about the focus, which is the general partnership piece of it. Your Honor, Judge Murphy, you asked the question, what facts push it across, the question was asked, what facts push this beyond the idea of possible to plausible, the idea of a general partnership? And the answer is none, because the critical part of being a general partner under Colorado law and under the even the 10th Circuit law that interprets Colorado law is ownership in the enterprise and participation in profits and losses. And there is not a single fact in the plaintiff's first amended complaint that suggests any of these 77 individuals were, to use the words of Judge Easterbrook in the 7th Circuit case, in his concurring opinion, that they were on the hook for the losses. And that's the key part of being a partner as opposed to an employee. And the fact, and Colorado statute is clear, the fact that an employee gets paid compensation, which of course comes from the profits of the organization, doesn't make that person a partner merely because they get paid compensation for it. They have to be entitled to get paid profits and be entitled to participate in the management and ownership of the partnership. And there are no allegations that any of the 77 individuals had the right to participate in the management or operation of the law firm, or that, most critically, they agreed to share profits and losses. There was a question asked or an argument made that there's no terminology about use of non-equity partners that in the affidavits or other representations made by these lawyers. That doesn't matter. The plaintiffs specifically allege that these 77 individuals were employees of Mesner Reeves. Mesner Reeves has a amended and restated partnership agreement that was submitted in the record. It has the certificate of registration with the Colorado Secretary of State, which was a public record, and the trial court could properly consider. And it's really indisputable that there is a law firm called Mesner Reeves that is a limited liability partnership, and that law firm has lawyers who are employed by the law firm using the title as partner. But that doesn't convert them somehow to a general partner in a partnership, operating in the same, outside of the context of the law firm. And that's critical because the law firm itself, Mesner Reeves Limited Liability Partnership, couldn't be the Rico enterprise when all of the Rico defendants are simply employees of the law firm, because there's no distinctness between the enterprise and the Rico defendants, and 10th Circuit law is very clear on that topic, based on U.S. Supreme Court law. And Judge Murphy, you asked, what is the difference between the Mesner Reeves firm, the limited liability partnership, and the Mesner general partnership? The answer is nothing. There's no difference. These lawyers were acting as employees of the Mesner Reeves limited liability partnership, and they used the title partner because law firms, particularly in today's day and age, have equity partners, non-equity partners of counsel, employees. None of those labels are dispositive of whether a lawyer working in a law firm is a partner as compared to an employee. And the Seventh Circuit's decision in that Judge Easterbrook concurring opinion that I referenced is very persuasive on that, the EEOC versus Sidley, Austin, and Brown and Wood. But you don't even need to go to the Seventh Circuit, because the Supreme Court's decision in the Clackamas case is very clear that the fact that a physician was referring to him or herself with some designation is not even relevant to the question of whether that physician was a partner as compared to an employee. And Judge Murphy, you also asked the question, it's not unusual for a law firm to operate this way. That's true. It's true not only from the Reuters article that the district court cited, but it's true from these cases that I referenced, the EEOC versus Sidley, Austin, Brown, and Wood case, the Clackamas case, and the other cases cited, and I believe it was footnote 12 of Appellee's brief, which are clear that the fact that a lawyer calls him or herself partner is not dispositive of the partnership status or the employment status of the law firm. And the plaintiffs advanced all sorts of theories about partnership by estoppel or partnership by representation. None of those are sufficient under the Colorado Uniform Partnership Act to establish a general partnership operating outside of Mesner Reeves, because there were no allegations, and there could be no allegations, that these individuals had the right to participate in the profits and, as critically, the losses of the law firm, or that they had to invest anything in the law firm in terms of capital that they put at risk to become a partner in a partnership to become a partner in the law firm. And even if every fact pled in the first amended complaint was accepted as true, the legal elements required to establish a general partnership are missing. The legal element of sharing in profits and losses, participation in the ownership and management of the firm, and compensation that's not just compensation, but compensation as a percentage of profits. None of those are contained in the first amended complaint. Instead, they allege kind of benign allegations, which would apply to every law firm with which I'm familiar. The lawyers practice together. They share work together. The revenue that comes into the law firm is used to pay compensation. The lawyers represent themselves in affidavits as partners. None of that would be sufficient to establish a general partnership under Colorado law, and it's pretty common for law firms to participate in that way. If you accepted the plaintiff's view and took it to its logical extreme, a law clerk, a first-year law student who's doing a summer law clerk in the law firm and represents themselves as sharing in the work, being part of a practice group, participating in moving the work around, that person would be a partner. That's simply not
But counsel, that
plausible.
person wouldn't call themselves a partner.
Well,
They'd call themselves a law clerk, right? We don't know.
We don't know. It depends on what the law firm, I suppose, would authorize for that person. I mean, it would, if I were participating in the management of the law firm, I'd say, no, you should call yourself law clerk instead of partner. But the point is the nomenclature used by that person is not sufficient to conclude that that person was a partner as opposed to something else. You need investment in the law firm. You need participation in the profits and losses, and none of those facts were alleged. And the district court was correct in deciding that. But even if you move beyond that,
Counsel,
yes,
you've been
yes.
very clear that one significant defect in the allegations is that there's no allegation of sharing in losses.
That's correct.
Can you just list for me the other critical absences of allegations? Or, what are the absence of allegations? Just list them for me that are very important to undercut the existence of Mesner General Partnership as an enterprise.
Sure. So in addition to the sharing in losses, there's no allegation of investment of personal capital into the firm to operate the firm, which is an indicia of partnership. Typically, two or more people get together, invest money into the entity, and then the entity does its a purpose. There's also
Can you have a partner? Can you have a partnership without that?
You could have a partnership without investment of money as capital. You couldn't have a partnership without something that indicates ownership of the partnership. So, for example, in Colorado cases, and we've cited them in the briefs, you could have a partnership if one person in the partnership is contributing labor and the other person in the partnership is contributing capital, or one's contributing land and one's contributing labor, something like that. But there are no allegations here that there were any personal contributions from any of these lawyers outside of labor, which of course would be a fact more indicative of the fact that they're employed by the law firm. necessarily.
What are other deficiencies? What are
Sure.
your list of deficiencies and failure to allege? What else?
Sure, participation in the ownership and management of the firm. So, and you heard Mr. Chase respectfully say, you know, based on the amended restated partnership agreement that Mesner Reeves LLP has, there's only one person who manages the law firm. That's frankly not unusual. It makes sense for a large organization to designate one person to manage the law firm, and that person can then delegate. But there's no allegation that any of these 77 individuals had regularly attended management meetings, directed the operation of the law firm in particular ways, had the authority to tell any of the other 77 individuals, you must do this or you must do that, could deprive them of compensation if they failed to meet expectations, those sorts of things. And then the final piece is participation in profits per se, meaning not receiving compensation as wages, or as an employee, but receiving compensations as a percentage of the profits. There's never any allegation that any of these individuals received some additional form of compensation or different form of compensation as a percentage of the profits of the law firm. And those are the essential elements.
That's no different than your primary view that the most important allegation that's missing is that there's no sharing of profits or losses. That's the same thing, isn't it?
It's part of that. It's the profits piece of it. The losses piece of it is also an essential component. And then one other thing that I omitted, and it's referenced in the EEOC versus Sidley, Austin, and Wood case and other cases, and that is receipt of some indicia of ownership. So either a share that suggests you have, X amount of shares in the partnership, or something that suggests that the individual person has some ownership. And there's no allegation that any of these 77 individuals received something that suggests they owned a portion of the firm.
What about, it's quoted in the district court's order, it's also paragraph 90 of the First Amendment complaint, where it says the general partnership defendants jointly decided on new and existing client engagements, work allocation, and revenue and profit division. Why is that not sufficient for the sharing of profits?
Well, several reasons. One, it's inconsistent with the limited liability partnership certificate that was filed with the district court. But second, the allegation that they participated in the profits was an allegation that they get compensated from the profits, and Colorado statute removes or says when compensation is paid as a portion of the profits, but it's paid for exercise of labor, that's not a share of the profits. Instead, a share of the profits would be the law firm at the end of the year has $100,000 in profits, and the 5 partners participate in some percentage in those that $100,000 as profits, as opposed to they get a paycheck every 2 weeks, or they get a paycheck every month, or something like that. The other parts of the allegation in paragraph 90 are just ordinary run-of-the-mill allegations of any lawyer working in a law firm. They jointly share cases, they share resources, they print from the same printer, they have the same secretary, all of those kinds of things, which would not be clearly sufficient under Colorado law. So for that, we ask the court to affirm the district court's dismissal for failure to state a claim.
Thank you.
Your Honors, the majority of the discussion there was about proof standards and not pleading standards. It's apples to oranges. There's no requirement that sharing in losses or contribution of capital, first of all, those are not requirements for a partnership anyway, but there is no case that talks about pleading standards. The Seventh Circuit cases, the Judge Easterbrook cases, those are cases on a full record at trial, what must be proven. There is not a case that says that if you allege that 2 or more persons carried on a business as co-owners for profit, and a lot more, paragraphs 83 to 98 set forth all sorts of information about how the partnership operated. There's no case that they cite that says that's insufficient. And what the district court did is said, well, I feel like that applies to a lot of contexts, therefore it's implausible. Wait a minute, if it applies to a lot of contexts and it's commonplace, then it's actually more plausible, not less plausible, that it's actually a partnership. There can be two different.
Is there an allegation, is there a specific allegation in the amended complaint of the sharing of profits and losses amongst the participants of Mesner General Partnership?
Absolutely, Your Honor. Paragraphs 90 and 92. Paragraph 90 talks about profit division, and paragraph 92 talks about revenue sharing. It is not required that the allegations include loss sharing. That's not a pleading requirement. Nor would we have a basis to say that
well, I'm interested, you know, what was the source of your ability to allege they share in profits?
All the information.
You did not have a source, let me finish my question. You did not have a source to allege they shared in losses. Help me on that. You had no basis to allege they shared in losses, is that correct?
I can't speak about the burdens of proof and the investigation that exists, but I can say that there's a lot of inconsistency with reality versus what was proffered as to the LLP agreement. We've seen no employment contracts.
My question is, what is the source of the basis for alleging sharing in profits?
A lot of publicly available information. I can't.
Is that publicly available information alleged in the complaint?
The source of how, as in, have we seen the way that they actually calculate the compensation structure? Your Honor, we haven't seen that.
No. You alleged that they shared in profits. I just want to know what the source of that allegation is.
All the information that we've seen.
And if it's not alleged, just say it's not alleged.
It is alleged, Your Honor.
And what is alleged as the source of that information?
The source of the information is all the information that has been conducted in the investigation of this set of circumstances. I can't, Your Honor, I can't give a laundry list of it. I could circle back with a more detailed explanation of exactly how this comes to be a allegation, but I can't say that we've seen any of the records that they could provide.
Right. Thank you. You answered my question.
Thank you. Thank you, Your Honor.
Thank you.
Thank you.
Thank you, counsel, for your helpful arguments, and the case stands submitted, and we will move on to our last case of the day. All right, I would call United States versus Osage Wind, number 255004.
Thank you, Your Honors, and may it please the court. Miguel Estrada for the NL Appellants, and I will try my best to save 4 minutes for a bottle.
Again, you have to keep track of your own time. Thank you.
I can see it's a tough room. Thank you, Your Honor. My fundamental point today is that the retention today of crushed rock that was severed from the mineral estate years ago is not a continuing trespass, nor a trespass of any kind, is not an invasion of realty. It is, we concede, a conversion for which we have accepted liability and for which the court awarded damages of $245,000 that we are willing and ready to pay. Those damages for conversion under Oklahoma law do not support attorney's fees of several $1 million as were awarded. Therefore, we submit that the disposition of the case should be, the injunction should be reversed, the damages for continuing trespass should be reversed, the conversion damages should be affirmed. Now, as to the fundamental point, it seems to us cut and dry. Even the government at time concedes that once the rocks were severed and crushed, they ceased being part of the mineral estate and became personalty. As a general proposition of law, personalty can be converted, but is not usually the subject of a trespass. With respect to the record here, both complaints affirmatively pleaded that what happened in this case was there was excavation, and under the ruling of this court, some of the rocks that were obtained in the excavation were crushed. Both of the complaints alleged, and the record is clear, that after the foundation for each of the towers were poured, there was concrete that was poured and cured. Those rocks were then poured on top of the concrete foundation. So that what we're talking about is crushed rocks that were severed from the mineral estate that are providing backfill support on top of the concrete foundation and around the concrete foundation. It is not part of the mineral estate, has not been part of the mineral estate for at least 12 years. That ought to conclude any claim of continuing trespass. All of the additional arguments for the giving of an injunction seem to us also to have a fundamental failing of law. There is the notion that an injunction could be based on the notion that there was an invasion of the tribe's sovereignty. I would say to you that the Supreme Court's ruling in Marion versus Curiae Apache, 1982, Justice Thurgood Marshall opinion for the court is controlling on this point. And I'll just take a second to remind the court of what the case involved. It involved mineral leases given out by the tribe with the approval of the Secretary of the Interior.
Didn't part of the district court's analysis with respect to that aspect rely upon the finding of the continuing trespass? Wasn't the notion that tribal sovereignty was not being respected or honored in part because the district court found that there was a continuing trespass and that, or your client hadn't gotten a lease in the years since the 10th Circuit's opinion?
Yes. That's the second aspect I was going to get to, and I was going to separate, the claim of an invasion of sovereignty with the claim that there should be a lease obtained now. So let me deal with the sovereignty point first, which we think is controlled by the Marion case, where leases were at issue, and there was an effort by the tribe who gave the mineral leases then to tax the income from the leases. And the assertion was, no, you've already exercised your sovereign power, you're essentially a stop, this is all you can do. And what the court said was, no, with respect to the leases, and this is from page 145 of the court's opinion, 455 US, you're essentially a commercial partner. You're not a sovereign. This is what, the court said. And to confusing these two things, this is from page 146, denigrates Indian sovereignty. So the court said, this is a commercial thing. It's not sovereignty. You can then turn around and tax it as you would any other commercial enterprise. So our point on sovereignty is that, yes, we were guilty by not having obtained the lease in 2014, which would have made the entry privileged, and not having settled on a royalty then, which would have then made the taking not a conversion. We were then guilty of a simple trespass and a conversion. A lease under the ruling of this court should have been obtained in 2014. Not having obtained those things, we conceded in the district court that we were guilty of trespass, simple trespass, and the conversion. Now the question is, the government says, well, it is an affront that merits some injunction that you haven't obtained a lease since. First point of that, under no theory could there be an injunction that ejects us from the surface estate where we have every right to be under the Osage Act and this court's 2017 ruling. So if there were any need to obtain a lease, the remedy could not possibly be that you get ejected from your own property. That's point one. Point two is the government has never given any support for the proposition that the regulation as written anywhere contemplate that a lease can be obtained retrospectively. The lease, all of the regulations are framed so that you can obtain a lease to license the entry and then pay for the royalties. And as I'm sure you know, there is a whole body of law having to do with retrospective regulations. There is the Georgetown University Hospital case from 1988 in the Supreme Court, where Justice Scalia, in his concurring opinion, pointed out that when agencies write rules, they have to comply with the APA. And the definition of a rule in the APA are sort of norms that have prospective application, as opposed to adjudication by agencies that deal with things that have happened in the past. And the whole thing about a rule, these are rules, they were promulgated by the agency to have prospective application. The agency, neither the agency nor the OMC has ever identified a single passage in any part of the rule that says this is how you go about licensing conduct that has already occurred. There is not a single sentence that they have identified. They have not identified a government website, promulgation, a single example of where this has ever occurred. I will compare the circumstance in 2017 where the government had asserted that we needed what they called a sandy soil permit, and this court found that that had no basis, even if they had once pointed to a single example where that had been done. Here, they have pointed to no administrative record of anywhere how to obtain it, where has it ever been done, how to go about it, or any language in the regulation that could possibly authorize it. And it would be contrary to the whole concept of the APA, the rules being a prospective application. I will say that should cover, the point about the injunction, except one more thing, which is also part of why the injunction is unjustified. Even if we were wrong as to anything else, the plaintiffs themselves submitted evidence that their injuries for the purported continuing trespass were compensable by money damages. They submitted the testimony of Haslett, which, the court concluded was not reliable. But then the court came up with her own measure of damages based on a regulation that no one had cited. What the Haslett and the regulation have in common is there are measures of damages based on the surface estate. Now, one can quibble whether that's wrong, whether that's logical, whatever. But if one accepts their premise that there is a continuing trespass, under their view and the district court's view, this is a continuing trespass that is compensable by money damages. And under hardcore injunction law, it is therefore not a harm that could ever be considered irreparable. Under the ruling that was issued by the court, continuing trespass damages are compensable by a certain sum to be continued at the rate of $8,000 per annum until we tear down the farm. And if that's true, we could capitalize that for the life of the farm and figure out what the harm of the trespass is. But the fundamental point is you can't have a continuing trespass for the possession of the property that you converted.
Well, counsel, let me stop you there. I think the district court found that there's a continuing trespass here because in our prior opinion, we defined mining as exploiting the resource, and you're still exploiting the backfill. And that is a continuing trespass. Tell me why you think that is incorrect.
That's incorrect as a matter of the ordinary dictionary meaning of mining, as a matter of the regulation,
Well, okay,
and as a matter of this court's opinion.
Oh, okay. Let me start with this court's opinion,
Okay,
because that's it. And also, I guess a sub-question there is that what governs the question of what constitutes mining in this case? Should we
Sure.
look at anything else, or should we just look at what we said in our previous opinion?
well, I think, the regulation sort of speaks for itself, and if the question of mining were controlling on the question of trespass, you would have to look at the regulation itself rather than the opinion, because, the opinion may interpret, the regulation, but if the situation has not exactly arisen, you would have to look at the regulation. My point to you is that this court actually dealt with the question, and mining, it conceded, actually requires extraction plus treating. And so you cannot separate, the fact that there is no ongoing extraction of anything. There has not been any excavation for more than a decade. And I know this from the passage in 1090 and 91 and footnote 11 of this court's opinion, where this court focused on the fact that the phrase directed to the severance had to apply to the entirety of the regulation. Severance, of course, is part of actually going in and getting something out, which hasn't occurred in over a decade. That's
How about the word exploitation?
Yeah, that's
Aren't they exploiting by having the backfill still there?
Yes, but my point is that this court's opinion, each time that it dealt with the exploitation, was presupposing that the severance was ongoing, because each of those passages speaks of the excavation and asks what more is needed. And the reason that was needed is because this court also conceded that excavation of the dirt by itself would not be mining. So it was looking for the plus factor that would turn it into mining under the facts of the case. If I could save the remainder of my time for rebuttal.
Thank you.
Thank you, Your Honor.
No, just a minute.
No,
Just a minute.
Sorry.
I have a
No, you may
question.
not.
So you may not. Are you saying that the only reason why this is not exploitation and therefore not mining is because it had already been excavated?
Yes.
Is that correct?
And in that way,
All right. You do concede, though, that initially there was mining.
that is the holding of this case. And so, yes, we do concede that there was mining to the extent that the rocks were taken and crushed, but not merely because of excavation or construction generally. And I would like to reserve the remainder of my time for rebuttal. Thank you.
May it please the court, Nolan Fields for the United States, working with the Osage Minerals Council. I'd like to reserve 5 minutes for them, and I'll do my best to hold to it.
That's your responsibility.
Yes, Your Honor. May it please the court. Here, Enel was never a commercial partner with the United States, so because it had no lease, Marion is inapplicable. Mr. Estrada offers that there's no offer of how the lease should be obtained retrospectively. The court already confirmed in its 2017 opinion that a lease needed to be obtained. So for Enel to blame the United States and the OMC for that failure, it's not the victim's job to let them know how to apply for a lease. They've known how to do it since 2013, and they've willfully, and as a bad faith trespasser, which the district court found, refused to take that step.
So do you contend that they're still mining?
Absolutely.
Okay, and explain to me, so this is one of the issues that I struggle with. So I read the 2017 opinion, and with respect to extraction, it talks about action upon the extracted minerals for the purpose of exploiting the minerals. So explain to me how this rock that's already been mined, like it was pulled out, it was crushed, it's now just sitting on top. How is that still mining?
But his characterization is incorrect. Based on the facts of the case, it's not just sitting on top of the foundation. It's backfill under the foundation, beside the foundation, and on top of the foundation. And so what the court did in its 2017 opinion laid out 4 examples that constituted mining, including, but not limited to, the extraction or excavation, the sorting, the crushing and the use. And so by including the use, they explicitly explained that the ongoing exploitation was mining, and the court even took the
Did
step.
they include the use as part of the mining, or was it action upon
No,
the extracted material
that was already
for purposes of backfill?
the 2017 court specifically disabused Anel of its attempted narrow reading of the mining regulations. And it unequivocally, in that 2017 opinion, it said, the problem here is that, I quote, that Osage Wind did not merely dig holes in the ground. It went further. It sorted, it crushed, and then exploited the crushed rocks as structural support. And there is no dispute that that exploitation continues. So when you want to talk about severance, physical severance, not legal severance, because Osage Wind cannot legally sever unalienable tribal property without a lease. That is the only way they can do it. And so without that lease, that's the reason the court is not, is correctly finding a remedy for this.
The backfill is benefiting the surface estate. And as it is now, it's just inert and has no effect on the mineral estate.
But it's not inert. But for the backfill, if it was removed, these turbines would not be able to function or stand. So it's inherently part of the commercial operation. That's why the court in 2017, even without the benefit of discovery at that procedural posture of the case, all that had happened was two declaratory questions came up. Is it mining, and is a lease required? And the court came back, and in its 4 examples that showed what mining constituted, notably, only one of them is the extraction. All the other 3, sorting, crushing, and use, are considered mining, and they are after the minerals have been removed. While they are physically removed, they are not legally severed. And that's the reason the court crafted the ejectment remedy, because it cannot be more narrowly tailored. Because if they don't take a lease, there's only one entity that has a say on how tribal property rights can be alienated, and that's Congress.
As the litigation progressed, there came a point where the district court inquired whether or not the backfill could be removed. And the lawyer for Osage Wind had no answer to that.
That's correct.
So that's over now. But the does that mean that a part of our solution cannot be that as part of an order sending it back to require that there be an evidentiary hearing as to whether or not the backfill is essential to the continued structure of the turbines?
That was already found in the 2017 opinion. There are multiple places in the 2017 opinion where this court noted how specifically the structural support of the backfill for the turbines, i.e. the use.
I absolutely agree. I remember reading it and said it several times because I was looking for it. It did say that. But the other side of the coin is it essential? Can it be removed and not adversely affect the stability of the turbines?
At the time, when the court specifically had a letter briefing before the motion for summary judgment argument, there was a month advance lead time, and the court said, please explain this point if continuing trespass can be abated by the removal of the backfill. Both the OMC and the United States explained that that was possible and were intellectually honest. And unfortunately, Anel did not provide any information. It specifically whiffed. And then only after the court had issued its order stating that it was going to eject the wind farm, did at that point Anel balk and come up with a middle-of-the-road replacement option, which was not asked for by the court. The court only asked, how long is this going to take? So in that briefing, what this is, it goes to an abuse of discretion standard, which is the court should get great discretion to control its own docket. But for the most part, the United States would like to pivot back to why we win. This is not a simple commercial transaction between the parties as Anel would like to have it be. This is the scale of a trespass that would be the equivalent of 84 wind turbines across 8,400 acres. That's literally the height equivalent of 84 Statues of Liberty across 10 times the size of New York's Central Park. That's also half the size of Boulder, Colorado. The volume of the OME at issue is over 300,000 tons. So with all of that information, what Anel does not want to talk about is that their continued use and exploitation without a lease is continuing trespass, and it's not on some obscure private party, it's on a sovereign tribe, specific reservation of minerals that is to be protected as trustee by the United States. And so they are flouting that, and they cannot alienate something that only Congress has delineated how they could do it.
So would you contend that there was still a continuing trespass if they had just taken the backfill off-site?
If they don't have a lease, they're still mining. So we can get into hypotheticals of where it's located, but they didn't take it off-site. They literally put it back in place.
Right, but when does mining end to you? Like I'm struggling
There's
here.
only
I'm
two
trying
ways.
To be honest.
It's unfortunate. It's two ways. They either get the lease, which is the way that Congress has said that you can alienate this properly, or they can be ejected. So the problem is with these...
I'm sorry.
No, it's okay.
Just have you repeat that. They cannot end mining activities until they leave or are forced to leave.
They could get a lease, or they could be ejected.
And anything they do is mining up until that point.
Well, at this point, the 2017 order has delineated what mining is. There's no reason, I think, for the court to delve into hypotheticals because it's laid out here in 2017.
You haven't given us an answer to the hypothetical. You didn't answer Judge Teeter's question about the hypothetical,
okay.
So I'll ask it again.
Yes, ma'am.
They take the backfill or whatever, the material, and they take it 1,000 miles away, and
right.
They build a road with it, and that's material is sitting there. Is that mining? I guess.
Yes, it is mining.
It is mining. Okay, so
yes.
How is the 1,000-mile away mining?
This court in 2017, it's mining because they don't have a lease. If they were allowed to a certain distance or a certain amount of money, that would obviate the fact that there are federal regulations and sovereignty. It's specifically regarding that. Otherwise, you would have no one ever seek the lease. All they would do is rush to quickly get it out of the ground, like the land rush, ironically, in Oklahoma, so that they wouldn't have to comply with the regulations and they could pay a paltry amount, which is not what the Congress has authorized.
Okay, so I understand now. You're saying because of the sovereignty element, this is different. And
because of what Congress has said, the only way that it can be severed is one way. So the court in 2017, and I'll quickly end, said, quote, this type of mining does not fit nicely into the traditional notions of mining as the term is commonly understood. So as much as Anel would like to pay for their trespass and make it seem simple, it is nothing but because they never addressed the sovereignty of the Osage Nation and they have illegally attempted to sever unalienable tribal property. Thank you.
Thank you. May it please the court, my name is Jeffrey Rasmussen for the Osage Minerals Council. I'm going to try very hard not to refer to them as the tribe, but I do it all the time. So I wanted to turn to Judge Murphy's question about the, excuse me, what Anel now claims is the narrower option. And what they're talking about is, lifting the existing wind structures up, removing the rock that is the use, that they've admitted they're still using it, and then taking the Osage Minerals rock out and replacing it with rock that they purchased elsewhere. And in many cases, when you're dealing with, is there a narrower option, you're dealing with something where the court can see there's a narrower option. And in this case, what the district court asked Anel was not, is this an option, but is this possible under construction methods? And Anel said, there's no evidence in the record of that. There's no evidence to support that in the record. That's what they said. The court then issued the summary judgment based upon that. So when we're talking often about narrower options, we're talking about something the court can say, oh, here's a narrower option. You can just not, you can allow the protesters closer or things like that we know are possible. Here, the court's question went to the facts of, is it factually possible? And Enel said, no, there's no evidence in the record of this. And the court then issued its decision saying we're going to have to evict the wind farm because there's no evidence in the record of this other option being possible. And it was only after that that Enel then submitted what it calls the replacement option, and it did so improperly. The court had asked for a briefing on a particular topic, and Enel volunteered, oh, can we go back to that? And that's one of the reasons we're 15 years into this, almost 15 years into this case, is that Enel goes for their big win, and when they lose, they then go back and say, let me try this one again. And so what they're trying to do now with this option is exactly what the judge asked, which is, well, could we remand? And that's what Enel wants, because then they get another 5 years of operating this wind farm before it can be removed. So no, it is not an option under the record of this case. Similarly, Enel said, yes, we are still exploiting those minerals because we are using them as the foundation upon which these turbines sit. So we basically have 84 mines on this land, 84 mines that don't have a lease on this land where they're using the minerals, they're exploiting the minerals. And I wanted to go back to why that was part of the prior case.
Let me ask you this. What if, I have one of those what ifs for you. What if this court just does not buy the sovereignty issue and says, no, this is all proprietary. You have non-tribal members with head rights that are affected by this, so it can't be sovereignty.
Right.
So accept that.
Right.
But also accept the proposition that the continued presence of the backfill is deemed to be mining. What then? The company can say, well, we expect millions of dollars for this. And Introl says, well, it's not worth millions of dollars. They're at loggerheads. What if no new lease can be accomplished? What then?
Right. Well, as far as legally a new lease can be accomplished, that wasn't an argument that I recall them making in their brief, that they can't go back and retroactively do it, but it can be. As far as if the court said there's no sovereignty, you get back to basic property rights, which is if you're on the property and you don't have the right to be there, and they don't have the right to have their 84 mines there, that would be a violation of basic property rights. So even separate from the tribal interests. But their reading of Marion is completely wrong, so we'd ask the court to look at that carefully.
Well, let me ask you this, based on what you just said, if that is so, but we also disagree that with the district court as to its measurement, its rental for the trespass, do we remand it then to the district court to have a new hearing on what the reasonable rental value would be of this area that is filled with backfill?
I think we did not appeal on that issue. We thought the court's decision on that was wrong, but what it's talking about is $8,400 when it was saying that when the wind farm is going to have to be removed, and so in that interim, $8,400 until it is done. So the court was very clear that it was saying this is just an interim measure because it's not a full measure of the damages or the full remedy. The full remedy is removal of that wind farm. That is what we want now, in part because of some of the things that Enel has said in its brief and in its arguments that we view as disrespectful to the Osage Nation and to the OMC as part of a sovereign. Thank you.
Thank you. Could you add 2 minutes to rebuttal because of the court's questions?
Thank you, Your Honor. Let me start by adding that there has been no rebuttal on the fundamental point that this is personalty and not realty. We can have a debate as to the meaning of mining if there were mining, which I'll get to. But this is a conversion and not a trespass, irrespective of the meaning of mining. But let me first address the questions that were raised first by Judge Teeter, followed up by Judge Ide, and then the question that was raised by Judge Murphy. First, the offsite versus onsite does matter because the regulation says what it says. And if hypothetically this were an emerald mine and I had gone in without a permit and stole the emeralds and converted them into earrings for my spouse, the fact that she was still going around wearing the earrings would turn it into a conversion. A remedy could be replevin, given back, in which case you would not be entitled to also seek damages for the value of the emeralds. Or it could be, give me the damages for the conversion, in which case you would not get the emeralds back too. You can't get both of those things, right? And so here, if you are getting the damages for the conversion, ordinarily you would not also get an injunction to get the rocks back. It's essentially a forced sale. That's point one. Point two, on the mining point, the text of the definition, both in the general definition, refers to severance and doing something with what has been severed. And then there is an exception that refers to extraction of no more than 5,000 cubic feet per year. Neither of those things would make sense if the passive possession of something could be mining, because the extraction on a per annum basis would stop applying on year two. And so as a textual interpretation of the regulation, the notion that the continuing possession of something that was extracted years ago being mining, if that were still relevant, wouldn't make any sense because it would make a hash of the language of the regulation. Point three, this court's opinion said we should have had at least in 2014. It didn't say when it's available now. It did not purport to construe the regulations. The consequence of that, of course, is since we didn't have one, we have to pay damages for the conversion. Judge Murphy, the 20 to 23 summary judgment hearing is very long, and we truthfully answered when asked, could you take the rocks back structurally? We have no record for that, and I think the counsel say I also don't have the engineering background to know. That was in September 2023. A ruling issued in December 2023 saying, I will grant an injunction. There was a request for clarification of the court. Is this an injunction? And she said, no, I am not yet issuing an injunction. Now the significance of that is, if there had been an injunction, we could have appealed and we could have brought the matter to the court. But as we pointed out, under the last sentence of Rule 54B, if a ruling is interlocutory, it's subject to change until the entry of the final judgment. It was open to us to then furnish the record that had not been available when the court asked that question, as we did then. Now, Mr. Field says she hadn't asked for the record, but she still had the duty to follow a correct interpretation of the law before she entered the injunction. I will note that contrary to the statements by the government and the OMC, that she said that we had waived something by not having the record at summary judgment, or that there was a forfeiture of some sort. Her opinion.
Thank you.
Okay, thank you.
Honor, can I address 214 in 30 seconds?
Yes.
Briefly. 25 CFR 214.9 is not some obscure thing that the judge came up with. It is literally in the regulations on how leases can get paid off, specifically in the Osage mineral estate. Advance rentals are what you pay to have the opportunity to have a lease and the exclusive right to mine. It's only when you then mine and produce something that royalties are also paid. So clearly, this is not something that the judge came up with. It's something that's in the regs specifically for this asset accordingly. Thank you.
So are you saying if you can't, just a second, are you saying if you can't reach agreement on a new lease, that you necessarily then get this advance rental payment forever?
You pay the advance rental while you occupy it. That's the only way you're able to occupy the area in question. So because Enel has never had a lease, they don't have the right to be there to begin with. So to pay $8,400 a year is a pittance compared to the $1 million that the surface owners are getting. It's just not equitable. Thank you.
Thank you. Any more questions from the court? No. All right, thank you, counsel, for your arguments. The case stands submitted. Counsel's excused, and we are adjourned until tomorrow at 9.